Hello, everyone. Welcome to the Borders in Globalization podcast. Today, we have the pleasure of welcoming Geraldine Giraudeau, professor of public law in France and specialist on international borders. First of all, Madame Giraudeau, can you briefly tell us a little bit more about your academic profile?
Yeah, sure. So thank you for the invitation. My name is Geraldine Giraudeau. I'm a professor of public law, specialized in public international law in the University of Perpignan. But I'm currently living in New Zealand and doing some research in New Zealand and working, focusing on the Pacific legal questions. I've been working on territorial disputes and law of the sea since my PhD.
Thank you for these clarifications. Thank you for your answer. Madame Giraudeau, can you give us some introductory milestones on the theme of international borders in general? What are their importance in law and what are their legal functions?
So as an introduction, I would first remind that state territory is definitely a cornerstone of the construction of our international society. Historically and politically, territory has always been synonymous with power. And although there are several legal perspectives on the function of state territory, it can be said that in this interstate Post-Westphalian Society, it constitutes the material basis, the practical basis for the implementation of states' competencies. And international borders are those that delimit this state space. Now, in a more dynamic approach, I would also mention that the world has obviously changed a lot. Cyberspace, for example, exists in parallel and can even compete with territorial space. But it is quite fascinating and even worrying sometimes in some aspects to see that international borders, state borders, continue to structure our world. Things have changed in that way, but not that much. So we are at a time when cross-border exchanges are daily and omnipresent, but we realize that the reference of the state space and its limits has remained widely unavoidable. And in this movement of withdrawal of that we are experiencing nowadays in the international society, and which is aggravated with the health crisis, international borders are more than ever brandished, defended, and even walled up.
Thank you, Madame Giraudeau. And if we could think a little bit about their legal functions, the international borders are separating the territories of states. And that's the main function of the territorial borders, that to separate the territories of states. And the territory of states is a space where the sovereignty of the state is applied. That's the main legal function of the international borders.
Yeah, definitely. This is the main function, to clarify, to make a special or geographical repartition of spaces where state competencies apply. Now, in the legal theory, you can find different versions of this legal perspective of international borders. But to make it short, like to focus on the main aspect, yes, it's definitely the main function, the main legal function is to delimit the space of the state's competencies.
Thank you, Madame Giraudeau, for these clarifications. And could we speak about the different types of borders? How are land, air, and sea delimited?
So as you mentioned, the state territory has three dimensions: land, sea, and air. As regards to land territory first, we can say that it is often the result of history. The land borders can be delimited by geography, by agreement between states, and these agreements can refer to geographical limits, but not only, obviously. So this land base is decisive, particularly in terms of resources. It includes internal waters, and it is clear when you look at a map that its extent, the extent of this land territory, is directly linked to the political position, the political power of the states. To make it short, the bigger you are, the stronger you are regarding the land territory. Regarding the maritime dimension of territory, it is something fundamental and even more in the beginning of the 21st century. The extent of the maritime spaces over which coastal states can exercise sovereign powers have evolved considerably in the second half of the 20th century, with claims to sovereignty going further and further out to sea, and with the famous codification of the law of the sea in the Montego Bay Convention. So the sea is definitely the territorial conquest of the 20th century. And from then on, an horizontal division was established from the baselines. So these coastal baselines are drawn from the low water mark and have certain specificities. We can have straight baselines in the case of indented coast, or in the case of archipelagic states, for instance. And from these baselines, we have first the territorial sea, up to 12 nautical miles, over which the state exercises its full sovereignty. Then a contiguous zone of 24 nautical miles, which corresponds to a zone of state jurisdiction. And above all, up to 200 nautical miles, the famous EEZ, the exclusive economic zone, over which the states do not exercise full sovereignty, but rather some sovereign powers, essentially focused on exploration and exploitation of resources. Above the continental shelf, that is to say the continuity of the continental slope, can justify the exercise of rights up to 350 nautical miles after a request was made to a specialized United Nations Commission. So as a result, there is sometimes, particularly in the case of islands, a surprising proportion between land territory and maritime space. I am thinking, for example, of Tuvalu with an EEZ, which is 27,000 times its land area, or Kiribati with an EEZ of more than 3.5 million square kilometers for a land territory of a bit more than 800 square kilometers. And finally, regarding the vertical boundaries of the airspace, they are measured from the land territory and the territorial sea, that is to say not beyond 12 nautical miles in width. And horizontally, there is no legal boundary between airspace and outer space. This has been widely discussed without success. So the law applied depends of the nature of the activities carried out, depending if we're using technology linked to the use of air or the use of outer space.
Thank you, Madame Giraudeau, for these numerous insights. You spoke about the territorial sea and the islands. I have a question for you. What are the key challenges the sea borders or the maritime borders of the states are facing currently with the climate change? Could you give us some words about the key challenges about this issue?
Yeah, for sure. Sea level rise, but also other effects of climate change are threatening baselines and so have consequences potentially for the delimitation of maritime borders. This is definitely one of the major concerns for a lot of governments of islands, especially in the Pacific. And there was actually a very recent declaration by the Pacific Islands Forum to ensure the maintenance of their maritime boundaries in the event of a change in baselines. So this will be one of the major legal issues of this first half of the 20th century regarding boundaries. And it is something that which is studied by the Commission of International Law in the wider framework of the analysis of international law and sea level rise. And it's not a theoretical question. It's something very urgent, very crucial in terms of resources for the island population and even for the existence of some of these states.
Thank you, Madame Giraudeau. We could move on the next question. Could you tell us a few words about the legal principles which make it possible to regulate territorial disputes?
So when dealing with a territorial dispute, we have to distinguish between a land boundary dispute, a dispute of attribution, that is to say when the issue is not the boundary, but which sovereignty has a territorial unit, for example, which state sovereignty exists over an island, or a maritime boundary dispute. So many disputes may involve more than one of these elements. Typically, an island dispute will involve questions of maritime delimitation as well. There are different legal principles applying depending on whether you are in one or another of these aspects. For example, there is no general principle governing the delimitation of land borders. So the judge would rely on agreements between states, or failing that, on what we call the effective manifestations of sovereignty. In certain post-colonial situations, another principle may have to be taken into account, the principle of uti possidetis iuris, which comes from Roman law and which implies respecting the delineation of former colonial borders converted into international borders in order to ensure the stability of international relations. For the law of the sea, for maritime boundaries, it is very different because there are applicable principles, although very general. So for the territorial sea, the principle applying is the equidistance line, except in the case of historical title or special circumstances. And for the EEZ and the continental shelf, the Montego Bay Convention only specifies that there must be an agreement with an equitable result. So international case law, that is to say decisions of the International Court of Justice, the International Tribunal for the Law of the Sea, the arbitral tribunals have contributed to the evolution of the matter and have recognized the primacy of the equidistance method, which may be weighted according to certain effects. So it all depends on how states settle these territorial disputes. In general, they will do everything possible to settle them by negotiation, if not by calling on a third party, such as a mediator, and more rarely, they will submit their dispute to a jurisdictional body.
Wow. Thank you, Madame Giraudeau, for all this clarification about these principles which regulate or tend to regulate territorial disputes, terrestrial or maritime. We have seen the technical aspects of international border law. According to you, Madame Giraudeau, what are the main impacts of the phenomenon of globalization, material globalization or legal globalization on international borders? Globalization has changed something, but what? Could you tell us something about this topic?
Yeah, it's not an easy question, but if you ask me about the impacts of globalization on legal aspects of international boundaries, borders, I think of two examples, which are two consequences of the way governments are concerned with how the international borders are threatened because of globalization. So the impact is that the material international borders appear insufficient to governments whose policies focusing on security issues. That is the case of cyberspace, where states have a very limited control, the regulation being mainly in charge of private actors, and the digital sovereignty of states is a current challenge. The same happens with migration and asylum. We observe how migration controls are strengthened, and how states tend to externalize, to shift the access to asylum process, to put some physical distance. And we recently saw this very well with the European Union states. So in the end, international borders are being externalized at the same time as the demarcation and materialization of existing international borders are being reinforced. So they are not replaced, they are actually duplicated.
Thank you. Yes, I think they are duplicating. And my own personal analysis about this transformation in the territorial border analysis, the lens of territorial analysis of borders is not enough anymore. We need to think as a border as a complex object, as a legal complex object with multiple dispositives and multiple ancrage. It could be a territorial ancrage, or it could be a functional ancrage. That's the idea I have when I hear your words. And I allow myself to pick up on your comment. You spoke about Post-Westphalian Society. When we start the interview, you spoke about this expression, Post-Westphalian Society. Could you give us some details about what do you mean by this expression, Post-Westphalian Society?
Yeah, I was referring to the construction of international society after the Westphalian Peace, which is usually the symbolic date which is taken to pinpoint how international society was built on the construction of states, on the reference of states after the end of the 17th century. And all the theory, the legal theory we have around international, or most of the legal theory we can find around international borders come from this moment and after this moment. But as you mentioned, even if the legal theory of international boundaries evolved a lot since then, it is probably the time to have a new legal perspective of the international borders and to imagine them as a more complex or multidimensional and functional object.
Thank you, Madame Giraudeau. To conclude this interview, could you share with us some advice about literature, legal literature, or in border study in general, or some key ideas to remember in the study of borders and bordering processes?
Yeah, I'm thinking more about ideas, and maybe my advice would be a very personal advice, and it would be to look towards the Pacific, because I find that the questions that arise there are fascinating. These legal questions exist at a global level, but they are raised in the Pacific with a particular acuity. I've been, as I mentioned in the introduction, I've been working on borders since my PhD, but I've been living in the Pacific for 4 years now, 2 years in New Caledonia and then in New Zealand. And this experience has profoundly modified my perception of the subject, or at least of the issues at stake. First of all, it made me more aware of the topicality of the decolonization process on the geography of international borders. The current situation in New Caledonia, where the third referendum of independence will be held in December this year, is an illustration of this. And beyond that, many territorial disputes involving France are linked to its colonial past, in the Pacific with Vanuatu, or in the Indian Ocean with the Epars Islands. The Pacific is also a very emblematic example of what is at stake in this century for maritime borders and maritime spaces, because of the rivalries in the Indo-Pacific, because of the difficulty of controlling very extended borders, for example, against illegal fishing, because of the concern regarding security of submarine cables and pipelines. And it is also a region that is at the front line of the effects of climate change. And we mentioned previously how climate change, sea level rise, but also other consequences of climate change threaten baselines, and so threaten delimitation of maritime borders. It also it is also an illustration, and that would be a very general advice, maybe for students, that we must not forget when we study borders that it means also a reality for people behind these borders. So I think maybe as lawyers or as specialists of international borders, we should keep in mind what it means for people behind the borders.
Thank you very much, Madame Giraudeau, for this wonderful interview. We are very happy to having you for this interview for the podcast Borders and Globalizations. And I wish you a perfect come back in Neo Caledonia, because you are going back to Neo Caledonia soon.
To New Zealand. I should go back to New Zealand.
So I wish you a perfect academic year, and see you soon. See you later.
See you. Thank you.
Thank you very much.